These are in listen-only mode.
Hi everyone, it's James from Quails here, from Community Legal Centres Queensland here. Thanks for your patience while we were running a few minutes late. Can I begin this morning's session by acknowledging the traditional owners of the lands on which we're dispersed? I know that there are people from all across Queensland who have tuned in today, and so I acknowledge traditional owners across the state. We're here in the Community Legal Centres Queensland office, so I acknowledge the Turrbal and Yagara peoples who lived by the Brisbane River and other traditional custodians of the land, and pay respects to elders and ancestors and any Aboriginal and Torres Strait Islander people who are tuning in today. Particularly acknowledge them given the disproportionate impact of family violence on Indigenous communities. Aboriginal and Torres Strait Islander women are 34 times more likely to be hospitalised than non-Indigenous Australians as a result of family violence, and so we recognise that when we talk about our role in responding to domestic and family violence through legal systems and structures. Can I, for those that have played before, just get you to raise your hand if you can hear me? We're on a new system at the moment, and just want to check that the microphone's working okay. Right, there's lots of hands going up. Thank you all for that feedback. That's helpful. If at any stage there are any dramas with the sound, please do type a question into the questions box, or otherwise let us know. So a couple of housekeeping things. There are two ways that you can ask questions on this software. One is to press that button that looks like a hand on your control panel. We'll see a hand go up at our end. It looks to us like you're raising your hand. We'll unmute your microphone, and then you can ask a question. The other way that you can ask a question is to type a question into the questions box, and we'll see it at this end, paraphrase it, and get back to you. Kind of takes care of the housekeeping stuff. We might also we'll send some information through at the end of the webinar as well. Can I thank our friends at Legal Aid for coordinating the webinar, and thank in advance our presenter, Lindy Hawkins-Guy from the Violence Prevention and Women's Advocacy team, who's really well qualified to speak to us about domestic and family violence law and our role as community lawyers and legal assistance lawyers in helping people navigate the Domestic and Family Violence Protection Act. So let me hand over to Lindy. Thanks, folks.
Thank you. Good morning, everyone. I hope you can all see me okay. Welcome to DV 101.
Do you want people to see you? I didn't know.
Oh.
They can't see you. All they can see is that.
Oh, okay. All right. That's fine. That's fine. Okay, so we're going to start today's session with just a little bit of an overview, and I know we are running a little bit behind. But basically, for those of you who, even for those who have practiced in the area, it's worthwhile just to do a little bit of a refresher over the legislation, how to complete the application form, what sort of orders you might like to seek from the court, then a little bit about the final process, what happens at the hearing, what the courts are really looking for, a bit about variations and withdrawals and common misunderstandings in that area, and time permitting, some information about family law if we have time, and then obviously questions, if I can ask you to note those, and we'll deal with those at the end. So this legislation really gives us the objectives, what the legislature was looking for, and it's a preventative piece of legislation. It's looking at protecting those people who have had violence perpetrated against them or threatened by someone else, and it's those persons who are in particular types of relationships. The legislation seeks to maximise their safety and protect them from future harm and preserve their well-being. Overall, it seeks to prevent or reduce domestic violence in our community, and we know what the dynamics of the problem. It's an enormous problem. It's been described by some as a wicked problem, in that it's a problem that's very difficult to solve, it's very costly, It's very interconnected with other problems in our community like health, mental health, homelessness, unemployment. It's also an area where success is very hard to measure, and there are often very strongly held views at either end of the spectrum. So how do we deal with a problem like that? We have to have a multidisciplinary approach. So it's not just a legal process, as we'll be looking at today, but it also involves the social sciences very much. And if you work in an area where you have access to either a social worker or a psychologist in your unit, it's important that you make those warm referrals as often as you can. Obviously about preventing and reducing the exposure to children as well, because we know the enormous negative impact that domestic violence can have on children. It's also about holding perpetrators of violence accountable for their actions. So we need to be prepared to have those difficult conversations with respondents when we're acting for them. Also about identifying, and this is a new concept, the person who's most in need of protection. So where the court is faced with dualling or cross applications, it's open to the court to make a finding about who that person is that the order should be made to protect. They need not make both orders, cross orders against each of the litigants. So the relationships that are covered by this legislation, you may well expect them to cover intimate personal relationships. It extends to family relationships and also less commonly informal relationships. So a situation where someone might be a carer for the other person, the second person in the relationship, but it's not a paid role, it's an informal relationship. Those sorts of things are also covered. Intimate personal relationships include all those usual sorts of the indicia of de facto relationships, similar to what you may have seen in the social security area of law, that we need to be able to establish that it's a genuine couple relationship, or there may well have been a marriage. You can rely on that as evidence of that relevant relationship. Let's have a look at the definitions next, what actually amounts to domestic violence. And there is still a lot of misunderstanding in the community about what is an act of domestic violence. Respondents and aggrieved are constantly surprised when you go through an application and you challenge certain behaviours. People are still genuinely confused about what will amount to domestic violence. It's obviously a very broad definition. It covers a great range of behaviours, and it's also recognising that domestic violence is often a pattern of behaviour that is designed to dominate, control and cause fear in the victim of that violence. The legislature have assisted us in providing a list of particular behaviours, like interestingly unauthorised surveillance, so someone who is constantly checking their partner's phone, who they're getting text messages from, for example. That would fall within the definition, apart from the more obvious sorts of threats to harm others, harm yourself, harm animals. All of those sorts of behaviours would fall within the definition. So let's break it down a little bit for next and look at the additional definitional sections that have been added to the legislation. And Section 11 covers emotional and psychological abuse. So that can include torments, making derogatory comments, intimidating, harassing the other person. And again, there's a list of examples that are included to assist you when you're preparing the application. Threatening to withhold medication, preventing someone from having contact with their family, either in Australia or overseas. That's a very common concern that many aggrieveds have, where their behaviour or their contacts is very limited by the perpetrator. And again, this is a very common source of complaint, that people are receiving text messages over and over again. Some people receive 10, 20, 30 a day. As to whether it's intimidating or harassing is very much, according to the jurisprudence, an individual thing. What may intimidate one person need not necessarily intimidate another. Social networking is also a common arena for abusive behaviour, where we're asked to seek conditions to protect aggrieveds who are experiencing that sort of abuse. Economic abuse, again, this is often linked to other more direct forms of abusive behaviour, but it's certainly, obviously, it's included in the legislation and it is relied on from time to time. So the sorts of behaviour that is excluding the aggrieved from economic decisions or participation in the household expenses. Also in things like removing property, retaining property. Often it may be a mobile telephone that then has the added disadvantage of isolating the aggrieved from sources of assistance and support whilst this intimidation and violence is occurring. We often hear complaints about aggrieveds who are coerced by the perpetrator to make false claims or sign documents they don't want to sign and won't benefit from. For example, hire purchase agreements to obtain certain items of property or telephone contracts and the like. Next, we'll have a look at the concept of exposure to domestic violence, and this links back to the objects of the intention to protect children. So this is not direct or associated domestic violence, but it's exposure in that children may hear, see, or even more subtly, they may be required to comfort the victim of the abuse, a parent, for example. They may observe the injuries or the bruises. They may be present when police attend. And all these are forms of exposure to domestic violence that may support an application to name a child. So how do we obtain an order? The first thing we need to do is get hold of the application and then work through the application, and it's important to understand the terms that are used. The aggrieved obviously is the person who's seeking that an order be made to protect them, and the respondent then is the person answering that application. There are different ways of seeking this sort of remedy. Firstly, you can make the application yourself as the aggrieved, or through police, and this is becoming more and more common as the zero tolerance message that has been circulated since the Quinton Bryce report last February. Police are much more likely to take action and bring the application themselves. Or an authorised person can bring the application on your behalf. For example, I saw an application just the other day that had been brought by a social worker at the Dolby Hospital on behalf of a maternity patient who had presented not only with injuries but also in fear that this would continue if she were to return home. It's always best for aggrieved to seek some legal advice, but it's not always possible. So the important thing is to get the application into the court as soon as possible. And you can access that on the court's own website, or you can obtain a hard copy directly from the Magistrates Court if that's convenient. So the court site is fairly easy to navigate, and you can just put domestic violence into the search engine and it will bring up the application and also that kit. There's a self-help kit there that is very useful. It gives you a pro forma and some ideas about completing the form. Also, our own website, Legal Aid Queensland, has a very useful kit, again with a completed mock-up of an application so that you can see the sorts of claims that can be made that are likely to be successful for your client. So what sort of things go into the application? Firstly, the details about identifying who is the aggrieved, who is the respondent, and then the applicant, if that's someone different. As we said before, it may be a police officer or it may be any number of authorised persons. If there's a situation where the aggrieved is at particularly high risk, she may not wish to disclose her whereabouts, and that can be dealt with by an annexure called the DD1C, and her details will remain undisclosed. So it's like a cover sheet on the application. Obviously the magistrate will have access to that information as well as the police when they are having to effect service. So it's useful to be aware of that if there are concerns about the aggrieved being at high risk. You may have a client from a culturally or linguistically diverse background, and you may feel that she or he would be assisted by an interpreter. There is provision on the form for that to be just a checker box, and that brings it to the court's attention. Unfortunately, that's not a guarantee that there will be an interpreter available on the day, and often the court takes a policy approach that they won't engage an interpreter on the first return date of the application. Sometimes they require that an order be made by the magistrate before they'll appoint the interpreter, and sometimes, unfortunately, the practice does vary a lot from court to court. Sometimes the magistrate won't appoint an interpreter at all, and it will then fall to the client or the representative to ensure. The bottom line is that you need to understand your instructions and you need to be sure that the person you're advising understands the advice you're giving as well. So you may need to use your own phone and ring TIS and organise an interpreter until you're able to have that order made by the court. As much detail as possible about the respondent is always appreciated by the police. If you're it's a similar sort of role as if you were instructing a private investigator to effect service of documents. So information about their motor vehicle, the rego, where they work, any information that details their whereabouts is of assistance, because the consequences can be quite serious. It may lead to the application being dismissed. Unlike other jurisdictions, there are no specific provisions about substituted service, so the only way to proceed with the application is to ensure that the respondent ultimately is served. This is another area where there is a lot of misunderstanding. Understandably too, that when an aggrieved is completing her own application, a temporary protection order, it doesn't really convey a great deal of information, and sometimes it's overlooked, sometimes that box is not checked, and the court then forms the view that a temporary order is not sought. There's always provision to make that application orally if you know you can do that, and if there's a lawyer there to do it on the day, or if the aggrieved links in with a duty lawyer service on the day. But it's important to be aware that that box is there to be checked, and give details, brief details of course, as to what, where, who, when, as much as possible, but keep it brief. Importantly, the impact that the occurrence had on the aggrieved needs to be stated there. So why the temporary order is required, why it's not safe to simply wait for the next return date, or the date the court would ordinarily set as the first return date, which may be a week or so away. So you need to make it clear. For example, if the respondent is a FIFO worker and is due back on Friday, make that clear in the temporary order section of the form, so that the magistrate is in no doubt that the order is required prior to it being served on the respondent. As with any application, the gathering of evidence is very important, and if your client has photographs, text messages, get them printed off. If she's able to produce a doctor's report as to injuries, associated family court orders, print them off. Even Facebook pages, if they contain threatening or derogatory material, attach them to the application at the outset. Try and limit it to, I always tell clients 3 things, if possible, is a good rule of thumb, because we don't want to make the application too onerous for the magistrate on the day, because they may have 30, 40, in the court that I appear, up to 100 a day to deal with. So we need to make their job as easy as possible. Question 5 links into, as we saw at the outset, only relevant relationships are covered, so you need to detail the type of relationship you're relying on. And then at question 6, the grounds of the application in more detail. So we talked about the grounds for a temporary order, why it's particularly unsafe to wait, why you need your order to be made without service. This part of the form allows you to elaborate. Don't use, don't write War and Peace. There's no need to provide pages and pages of information. It is a fairly abridged process, but it is an opportunity to give a little more detail about the history and those events that may not be the most recent. So again, try and limit it to 3 significant events if you can. You can't always do that. Questions 7 and 8 relate to named persons. So these are children, family members, associates of the aggrieved who she claims are also at risk of harm, and if they are named, they will also be protected by the order. Question 11 refers to conditions, and we'll deal with that in a little more detail. You need to indicate what conditions you're seeking, what additional conditions, and why you're seeking them. Sorts of things that can be covered there, in addition to the mandatory condition, are to prohibit certain behaviours that you've complained about in the grounds. So if the complaint is that the respondent is contacting you over and over again, you may seek a condition that prohibits that conduct. What we see here is an example of an application, And this is the part of the form that we spoke about requiring or requesting a temporary order to be put in place. So an order where the respondent is yet to be served. So it's very important there to check that yes box. Even Queensland Police Service will make that error from time to time and whiz through the form and not check the box. So the magistrate then is not alerted to the need for a temporary order, and more importantly the registry staff are not alerted to that requirement. So the application might be given a later date than it might otherwise require. As I said, you can always make an oral application if that's missed, but it's best to get it right from the outset. So no doubt you've had a little read through that scenario, and importantly the fact that Bobby says he'll be back tomorrow, so you better do what I want you to do or there's going to be serious consequences. They're the sorts of things the magistrate needs to be aware of, and at F there's a statement that the aggrieved is worried because of these things that have happened. He'll again lose his temper, he'll attempt to hurt her if he comes back to the residence. So that's the sort of thing that would support a temporary order. Then under item 6, the grounds of the protection proper allow you to elaborate and provide more information about a little bit of history and other incidents that may have occurred that have caused concern. So in this example, I'll just give you a second to have a read through it. You can see the calls have been made to the workplace. The perpetrator's spoken to the aggrieved's employer. Derogatory, insulting, threatening comments have been made. And then at D, he's also come to the house. So that will inform the sorts of conditions that you'll be seeking in your application. The mandatory condition is that the perpetrator be of good behaviour and not commit any acts of violence in the future. So that's always the first condition you'll see in relation to the aggrieved, and also in relation to the named people if there are any. And then the court needs to look at what's necessary and desirable in relation to those additional conditions. So back to our example, the court might say it's necessary that Bobby be prohibited from making contact with the aggrieved. The court may also consider naming the employer as an associate of the aggrieved. And there may also be the need for a condition that the respondent not come to the place of residence or the workplace of the aggrieved. Conditions can also be made around the collection of property from the house. This is in the event that the aggrieved, rather than remain at the property, chooses to leave the property for her own safety. The court can make a condition of the order that she be permitted 7 or 14 days to make arrangements with police to accompany her back to the house to collect items of personal property. It is restricted to essential items like clothing, toiletries, medication, documents, those sorts of things. It's not intended to be a quasi sort of property settlement to allow the aggrieved to take, a U-Haul truck and empty the house out based on that order. And it's, but sometimes It depends on the magistrate, and I have seen orders made for the collection of a pet dog, for example. Maybe not an essential item, but, you know, it was one that caused an issue that caused a great deal of anxiety and concern for the aggrieved, and the order was made. An ouster condition is a special condition that allows the police to turn the respondent out of the family home. Now, traditionally, this was it was a fairly controversial sort of condition to include, and the magistrates were fairly reluctant to make these orders because they saw it as really interfering with people's proprietary interests. But now the legislation is very specific about prioritising the safety and stability of children over and above those proprietary interests. You can see the sorts of conditions or considerations, I should say, that are taken into account. So, if, for example, the child attends school nearby, has friends and social supports, those sorts of things are very relevant considerations for the magistrate when making those orders. The accommodation needs of the respondent are still there for consideration, but they're not paramount. They're not the only thing that the court will take into account. Similarly, the court can make an order allowing the respondent to announce a condition to return and collect items of property. But that, again, does not include property that may be needed by the persons remaining in the property, for example, white goods or things of that nature. There's also been a fairly recent amendment that requires the magistrate to now consider the wishes of the aggrieved. So if the police make an application and it includes a request for an ouster condition, the magistrate is obliged to entertain the wishes of the aggrieved. And it may be that the aggrieved feels that the risk is too high, they do not wish to remain in the home, that they need to make alternate accommodation arrangements. And they may choose to relocate rather than remain in the home. So we've talked a little already about what sorts of conditions to seek, and in that example that we looked at, the sorts of conditions that you might ask the magistrate to include around that example are to prohibit those sorts of behaviours: calling the place of employment, coming to the place of employment, coming to the place of residence. You need to have grounds. You can't request, for example, a condition that the respondent not contact you if your instructions are that the aggrieved has been calling the respondent. So in that instance, is the protection necessary? Is it going to prevent a behaviour? No, it's not, because that behaviour is already occurring and perpetrated by the aggrieved herself. So you would counsel against or advise against seeking a condition of that nature. So we've jumped the gun a little. Let's talk a little bit about the named persons. We've looked at naming children who are exposed to violence. We've looked at naming associates like the employer, for example, and also family members. Back to our example there, perhaps Peter, the cousin who was assisting the aggrieved, may be named as a family member. But you can also name unborn children, and that order would then take effect once the child was born. The order can be varied then to name the child if it's necessary or desirable to do so. There may have been a threat to harm the unborn child, for example. When naming children, the magistrate must consider the risk to that child, the allegations that have been raised in the application, and they must consider naming the child even if it's not been requested. Children can be protected from not only exposure to violence, which is the indirect form of violence that we've talked about in an earlier slide, but also more direct forms of violence, and that's referred to or defined in Section 9 as associated domestic violence. If the respondent is opposing an order naming a child and the family has had some involvement with the Department of Child Safety, it's open to the court to request a copy of that file to be sent over to that court to examine any material that may be of assistance in identifying risk to that child sought to be named. If that's, and that's not commonly known, it's rarely requested, but it may be a useful tool for you if you're in a situation where a child is sought to be named and it's opposed. If that order is made and that material is provided to the court, then both parties are entitled to a copy of that material. And that can then help inform their decision about whether or not the order is necessary or desirable, and may well assist them in taking a certain course, as we lawyers say, or consenting to the order finally before it has to proceed to trial where no end of damage can occur to these sorts of relationships. So we've looked at this to some degree. Orders can be made on a temporary basis. So if the aggrieved comes into the court, for example, at 2 o'clock in the afternoon with the form completed, it can be listed before 4 and the order can be made and served by police that night. All the court needs to be satisfied of is obviously that relationship exists, that there's been some form, some act of domestic violence that they can rely upon, and the standard of evidence is, the benchmark is quite low to be able to convince the magistrate to make that sort of order. The court need only be satisfied that there is sufficient and, sorry about the typo there, that should be AND, appropriate evidence before they'll make that temporary order. And of course, if you're advising a respondent in that situation, it's important to let them know that the benchmark is pretty low and that it may be appropriate for them to consent to that temporary order until they're able to get further legal advice or gather evidence to inform their what course of action they're going to take on a final basis. Most aggrieveds are very nervous or fearful if they don't understand or don't know what to expect when they get to court. So it's good to be able to let them know a little bit about what to expect. After the temporary order's made, there may be another couple, 2 or 3 mentions before the application can be finalised. There could be difficulty, as we said earlier, about locating and serving the respondent. He may have moved interstate. The police may have difficulty catching up with him. Your temporary order will always be enlarged to cover that situation and provide the aggrieved with protection, but you won't be able to proceed to getting your final order until such time as there's proof of service. That's another common problem, that even if the respondent has been served, for whatever reason the police have not been able to produce an affidavit or a statement of service to the court file. So again, that will prevent the magistrate from making a final order on the day. The respondent may wish to adjourn the matter to get some further legal advice, and we've seen fewer delays in this area now since the Domestic Violence Duty Lawyer Service has been running, because respondents have been able to get that advice on the day and either finalise it on the day or go about gathering evidence to support their opposition to the application, or they may even make a cross-application if that's appropriate. Sometimes that is used as a particular strategy in these applications, unfortunately, but it may also be perfectly valid. For example, if there's a police application that's been made against someone who you then determine to be the person most in need of protection, the actual aggrieved, not the perpetrator, then you may want to advise them to file that cross-application before the matter's finalised. Then the hearing will deal with both applications and make a determination about who actually is the person most in need based on the evidence on the day. Every court event is an opportunity to try and resolve the matter. And again, this is a process that we've seen really develop with the DV Duty Lawyer initiative, that just as in criminal law matters there are case conferences about the weight of the evidence and what might be an appropriate outcome, a similar process is now occurring in these matters. We call them case discussions, where the duty lawyer or the legal representative for both sides can engage in some meaningful discussions. And at Southport we are now seeing body cam footage on the laptop of the prosecutor on the day, so that both lawyers can have a look at the weight of the evidence and give their clients appropriate advice and go off and resolve the matter on the day. So the importance is that in accordance with the Not Now, Not Ever report, we're not re-traumatising victims, we're not exposing them to these numerous mentions and then of course the trauma of a final trial or hearing, where we're resolving things on the day as quickly as possible with the least amount of trauma and ensuring that the persons who require protection are protected as soon as possible in accordance with the objects of the Act. Of course, the matter can be resolved by consent. Another way of resolving it is an undertaking, which is it's really just a promise, a written promise to the court and to the other party, and it may be appropriate in certain circumstances. I often don't recommend it because of the enforceability difficulties, but if you'd like more information about that, I'm happy for you to contact me after the event. We're just running out of time. Do we have someone else starting at 10? Or no?
No, you can go.
I can go?
Yeah.
Okay. Yeah. And of course the aggrieved is able to discontinue the application. And again, that may occur after there's been this case discussion about the weight of the evidence. You've been able to give some advice about the strength or otherwise of the case, and the aggrieved may choose to discontinue. The parties or their legal representatives, of course, must attend court. If they're not there, the application can be dismissed. The respondent, of course, is at risk of final orders being made in their absence if there's proof of service on the court file. The application can be resolved by consent, and it's important to have a bit of an understanding about how this works. It doesn't mean that the respondent is acknowledging everything in the application to be true. They simply make a without admission consent to the order being made. So it's a way of finalising the matter quickly without any adverse inference being drawn against them. And it's important, if there are family court proceedings on foot, to be able to give that advice to a respondent, because if they proceed to final hearing and findings are made that are adverse, that they committed certain acts of violence, particularly if they exposed or even worse committed acts of associated domestic violence against children, those findings then can be relied on in the higher court. So if they consent without admission, there are no findings made against them. If it's a police application, then usually the aggrieved is required to give that consent, but not always. If the police consider that the order proposed or consented to adequately covers safety, protection and well-being in accordance with the objects, then that order can be made even if the aggrieved is not in court. It's ultimately a matter for the court, of course, to make the order or not make the order. Having read through the application and considered the allegations that are made, the court may well find that there is too high a risk and the conditions agreed upon are just not sufficient to give the protection required. So bear that in mind when you are negotiating consent orders outside of court, that they do need to be reality tested against the risk of future acts of violence. Again, if you are acting for a respondent, it's useful to know about Voluntary Intervention Orders, or VIOs as they're referred to, and make a warm referral for your client to speak with a men's worker if there is one available at the court, because they can discuss with them the way the VIOs work, the sorts of programs that they can become involved in. Obviously they're focused on behavioural change, what we used to refer to as anger management, but they may also cover substance abuse issues, alcoholism. The idea, of course, is to address the behaviours to ensure that there are no further acts of violence and that the aggrieved is then protected, again linking back to the objects of the legislation. The respondent must agree to the order though, so that's why it's good to link them in with Men's Line or a men's worker if they're there, so they can have those difficult conversations about accountability, again linking back to the objects of the legislation. If anything in any of the acts alleged are true, there's a basis for the application. There may well be a basis for a behavioural diversionary program to be undertaken. It's also useful for the respondent, not only because it will assist them in resolving their problems with violence, but it may then give them the grounds to go back to the court to vary the order. For example, to reduce the conditions or to reduce the duration of the order. So they can go back to the court and say, look, I've done the course, this is the report, I'm a different person, this is what I've done, I'm now relating to my children in a much better way, there's no or less risk of this behaviour recurring. So that's often an event the court would need to deal with. So they have to agree to the order and also agree to comply with the order. Final hearings, again as a result of the Domestic Violence Duty Lawyer project, are quite rare in that they often do not proceed, but they are often set down, similar with other jurisdictions as you would have experienced. Currently in Southport there are 100 matters awaiting final hearing. So the court is often very proactive in managing these matters and will write to the parties, and sometimes directions are made that they actually present a statement addressing Section 37 of the Act, setting out the parameters of the argument. And what that does then is limits or tries to limit the area of dispute and the time that the court then needs to allocate for the final hearing. The court will make directions about the filing of affidavit material. It's rare that it will now proceed by way of oral evidence only. And the court will also make directions that if you don't comply with filing your affidavits on time, you may well not be able to rely on any other information or any other affidavit material. So there's a fairly serious consequence for non-compliance. Helpful if you're acting for the aggrieved, because you already have the application, your affidavit before the court. The respondent then may not be able to file anything at the last minute without leave of the court. However, I have to say from my experience that the magistrates will usually be fairly lax on enforcing those directions and will allow respondents, particularly if they're unrepresented, to file things at the last minute or rely on what they like, partly because the rules of evidence don't strictly apply. So when you're drafting your affidavit, keep the basics in mind. Go back to section 37. What are the requirements? You've got to have that relevant relationship. You've got to set out the details of the acts of violence. Again, try and restrict it to 3 things if you can. You can't always do that, but keep that benchmark in mind. And then address why it is necessary, how these behaviours have impacted on your client and what she fears will happen if an order is not made. Spell that out clearly for the magistrate. Be brief though, be as succinct as you possibly can. There's a template for an affidavit. I haven't given you the whole thing there, but you're very welcome to contact our service if that would be a useful addition to your templates. It's the when, where, who, what, and how it makes you feel, how it impacts on the aggrieved, why it's necessary for the order to be made. And this really follows standard drafting requirements. Be brief, be succinct, stick to the facts. If your client can't tell you when, try and urge them to link their memory to an event, for example. It may be around Easter time. Where? Was it in the lounge room of the residence we shared? What the address is? Who was there? That may give rise to other evidence that you can gather, affidavits from witnesses perhaps, and give rise to requests for other reports from police or hospitals in relation to injuries, or the issue of subpoenas to gather that information. Stick to the facts, provide the evidence and the annexures if they're available. Think about having that technology available for your client. Often they will say, I don't know how to download my text messages. If that's a problem, and I've seen this happen where the client's had to actually hand up her phone and be without the phone until the matter's been resolved, and you've got to make a request for the return of that exhibit. So be wary of that. If you can provide some assistance with that technology, that can be useful. Photographs, voice recordings, there's facilities now to tender that with an exhibit cover sheet into the court in support of your application. As I said, the rules of evidence do not strictly apply. It's open to the court to satisfy itself in whatever way it considers to be appropriate. So if things do come to hand at the last minute, always try to put them in, depending on the probative value, of course, if you think that's going to assist your client's case. gather witness statements if they're available. Ideally get your client to do that first, and then you can vet that evidence and speak to the witness, time permitting, of course. Issue subpoenas, and directions are usually made by the court on the last mentioned date, governing not only the dates for the filing of material but also the date for issuing subpoenas, the final date, and that will follow the filing of affidavits. Of course, the affidavits will help crystallise the issues and turn your mind to what subpoenas might need to be issued as not a last resort, but obviously you don't want to be heading off on fishing expeditions, issuing subpoenas willy-nilly. Then this is another interesting provision. If you feel that your client needs to be protected, particularly in a situation where the respondent is not legally represented, so you may want to make an application to restrict him from cross-examining your client directly, or you may want to set up another room, a video link, a screen, so that the applicant or the aggrieved doesn't have to look directly at the respondent. I was involved in a matter once where the respondent, even though there were no interpreters involved at the hearing, he persisted in cross-examining my client in Spanish. They were both Spanish speakers. So I had to get a direction from the magistrate to get him to refrain from doing that, and also asking him to face the wall so that he wasn't looking at my client when he was cross-examining her. Because all of these, these stresses can re-traumatise an aggrieved, and if we can protect them, all the better for the outcome. So self-represented respondents. It can cause distress and intimidation that can impact on the way they give their evidence. Important to note there that if you don't make the application, the court can do it of its own volition, but it's good to be aware of Section 150. So what outcomes can you expect? Well, we've talked about the orders, the conditions that can be made if the application is successful. The application can be dismissed. Even though it's fairly unusual, cost orders can be made, but only after the final hearing. So the court is actually required to hear and determine the application, which makes sense because how else would they make a finding that the application was malicious or false or frivolous if they hadn't heard the application. So cost orders can be made, but they're fairly unusual. You need to let the client know that that risk exists though, particularly if you form the view that it's not a strong case and you may not be able to continue to assist them with the matter. You need to alert them to the costs risk. 28 days to appeal to the district court. There's a non-publication section, section 159. So if your clients are avid Facebookers, do alert them to that potential problem that if they go and tell all their friends on Facebook about what happened, they may well face a criminal prosecution. If the behaviours complained of continue, you need to refer your client to police and encourage them to keep a diary of breaches. Encourage them to utilise their smartphones and take a photograph of the car as it drives past, the registration number, or whatever the breach complained of is. The more evidence they have to support it, the more likely police are to take it seriously. Whilst police are obliged to investigate, they do sometimes warn the respondent first before breaching him formally. So if you're having difficulties, I would recommend that you suggest or refer your client to a support service who may be able to accompany them. to the police station, request a conversation with the officer in charge or the domestic violence liaison officer, who can also have some influence over how these breach complaints are managed. Again, it's about the evidence. It's an evidence-based forum, so we must encourage our clients to collect whatever evidence they have to support those complaints. And penalties tend to be fairly minor for initial breaches, but you know, they can result in fines and imprisonment, so the courts can take these matters seriously. If you need to vary an order, there is another form. It's a DV4 instead of the DV1. Don't get them confused, because sometimes that can result in the application being dismissed. Have both of those applications on hand. Don't get confused though with an appeal. So you can't lodge an application to vary just because you want another crack at it. If a temporary order's been made, the court's heard and determined on the facts, you can't just go back and ask for a variation unless there's been a significant change in circumstances. Or, as I said before, you know, if you've completed the VIO, if the respondent's completed a voluntary intervention order, wants to go back and attempt to vary the conditions about what he can and cannot do, or the length of the order, that may well be a significant ground to rely upon for a variation.
Lindy, we've had a question come through, so I might just get your
Sure.
into the circuit there. Are there any consequences of a person failing to complete the VIO? If you could just repeat the question, people might have heard me.
Okay, so the question is, what are the consequences of someone failing to complete a VIO? If there's a final order in place and the order is for a duration of 2 years, the consequences are nil. A report will come back from Centrecare or whoever the provider is that the respondent has failed to complete, but as I said, it is a voluntary thing. So he would not have grounds to go back and vary the order, vary the conditions, reduce the duration because he hadn't completed, but there are no direct consequences for him, for example, a penalty or a breach.
Terrific, thank you.
Any other questions? I'm sorry we've gone a little over time, but you're very welcome to contact me at Legal Aid Queensland at any time if you have any further queries arising out of this presentation, or generally we're happy to give advice to practitioners.
I had another question come through, Lindy, and I'm pretty sure I know the answer to this, but maybe you could expand on it a bit. Have you ever known a family court to consider a protection order made by consent without admission?
Okay. The question is, will the higher courts, the family court or the Federal Circuit Court, consider an order that is made, a protection order made by consent without admission? The answer is yes, it has to be considered because it's in the legislation, but it's a question of weight. What weight should a court give that? Because no findings have been made, no evidence has been heard, it's simply an order that says these behaviours won't occur in the future. So it doesn't carry a great deal of weight, but yes, it would be considered.
And a question about the significance of metadata in some of the evidence questions.
Oh, the question is the significance of metadata.
Does it come up in your practice?
I'm not really sure. If I knew what metadata was, I might be able to say.
Sure.
Perhaps an example?
So one of the things that came up in a previous presentation that we had from council was GPS type data and how that might be used by a perpetrator as a method of control.
Right, okay. Well, we've certainly seen complaints about perpetrators accessing their partner's phones and putting on the apps that will track their whereabouts. So that would form part of the application. As far as evidence gathering is concerned, you would need to consult a technician who could actually give you a report about that particular device, what apps had been put onto the phone, how they'd been used, and then report as to perhaps locations that had been pinpointed, and then link that back to the allegations made by your client. So yes, I've seen the allegations made, but I've not actually seen any evidence of that nature.
Okay. Our question has given another example of telephone records. So while they might not show the content of a text message or the content of a call, they would reflect that a call had been made.
Yes, indeed, and that's a very common thing where that sort of intimidation is not acknowledged by the respondent. A subpoena is issued to the telephone carrier and those records are produced. You need to be a little particular about the dates, the range of the subpoena. Again, there can be an objection if it's seen as a fishing expedition, so include the numbers that you know are being used, your own client's number. You may have to issue the subpoena to a couple of different carriers if it's Vodafone and Telstra. But yes, those records can be subpoenaed and can be very useful at final hearing.
There are all the questions we have.
Well, thank you everyone for your attendance and participation, and don't hesitate to call.
Terrific. Can I, on behalf of the people clapping and cheering wildly at computer screens across Queensland, thank Lindy for that presentation. We'll email around a link to a full day CPD training on some related issues, looking at abuse and violence in families and crossover between domestic and family violence, family law and child protection, that's happening on the 1st of June for those that are in Brisbane. Thanks everyone for participating. Thanks to Lindy and the team at Legal Aid for pulling this together, and we'll look forward to speaking to you soon.